Hi, I'm Adam Summer. You're listening to the Yerushalmi Talk podcast with the support of the Yeshivat Javar Yerushalayim in Har Nof, Jerusalem. This is Peah, Chapter 3, Halacha 7 continued, and today we're going to be really getting into SHECHIV MERA. That's the deathbed gift, and we're going to really cover a lot of things with it. Now, keep in mind, this is really covering, still covering Peah. It's really still covering what happens when crops are cut and they're left on a field, because that's a movable property. And then with the movable property, and what we're going to be talking about today is going to look like it's not at all connected with Peah. What's this doing here? Why is this here? But again, Peah is an encumbrance. And if it's cut and the sheaves are there and there's nothing standing, the Peah is still in there. Now that's a movable property. And this encumbrance is going to be the same both here and there. So it's not accidental that the sages and the Hachamim put this in here. But we're going to get into a lot of depth with deathbed wills today. So the Mishnah is covering in the Yerushalmi style. They're gonna break out what is the Mishnah going to be talking about before they start the set of sugyas to cover what the Mishnah is talking about. And the sugya says, the Mishnah continued and says, to acquire movable property along with it by means of money, a document, or a proprietary act. So the Gemara is going to seek the source of the law referred to by this line of the Mishnah. So the sugya says, from where do we know that movable property may be acquired along with real property by means of money, a document, or proprietary act? So just, real quick about it, this mode of acquiring movable products is going to be, it needs a kinyan, because the movables that are acquired by the dint of a kinyan is performed on the land. It's a kinyan agav, kinyan agav, and it's the dint of an acquisition, because again, this is an acquisition that's performed for a movable while it's still on the land. And again, you can see how, if you have cut crops, that you're also going to be having some form of acquisition on somebody's land. So the Gemara is going to respond. It's because Rabbi Yossi says in the name of Rabbi Hiskiah, and Rabbi Yonah cited Rabbi Hanana Tirtaya, who said in the name of Rabbi Hiskiah. It is written from Chronicles 21:3, and this is dealing with the bequest that's made by Yehoshaphat, the king of Judah, to his children. So that's interesting that it's not using a source that's in the Humash. It's looking in the Tanakh, but nonetheless, this is what the sugya writes. So it is written, and their father gave them many gifts of gold and silver and delicacies, together with the fortified cities of Judah. And this is implying that the movable gifts basically were acquired automatically through the acquisition of the cities. I want to point out something from the Tosfot in the Bavli in Bava Kama 12a, and this basically is a kinyan agav, where you have, it's not the same as a kinyan where it's real property. Had the verse meant merely that he gave gifts, where you have movable property, and cities where you had real property, it would have said that their father gave them gifts and fortified cities to Judah. But the way this is written here is that this is really showing Kinyan Agav, where these movable properties are inside the cities. So by giving the cities and giving that property, they gave the movable property as well. So that's a very important point. And the Tosfot also points out that Kinyan Agav is Derabanan, and the source cited by the Gemara is not a true scriptural exposition, because we know that if something's going to really be Doraita, that it has to be in the Humash. You can't pull out sources for this kind of stuff from the writings. You just can't do that. So the Tosfot over there in Bava Kama 12a is saying that this is not a true scriptural exposition, but a rabbinic support to their ruling. Basically, it's an asmata. And there are some others in the Tosfot, Bavli, Bava Kama 104b, who disagree and maintain that the Agav is a biblical kinyan. But you can go over there and look at the Tosfot in 104b, Bavli Bava Kama, to see the dissenting view. So we can see that the movable gifts, in this case, in the writings, were acquired automatically through the acquisition of the cities. These were in the cities. When they acquired the cities, they acquired the movable property. So then the Gemara is going to ask, and the sugya goes like this. It says, until this point, we've heard about where the land and the movables were together in one place. But what if the land was in one place and the movables were in another place? In other words, it's asking, can the movables be acquired by means of an acquisition of the land in this case as well? In other words, you have movables located in another area that's not connected to the land, that's not on the land that's being given. Is that also going to be acquired? And the Gemara is going to try to resolve this inquiry of basically, well, what happens if we just established, and it's even in the writings, that hey, if the movable property is inside the land, in this case the cities, okay, it's all acquired. By acquiring the land, you've acquired the movable property, no problem. But what happens if the movable property is over there and the land's over here? By acquiring the land, did you acquire the movable property? So the Gemara is going to try to resolve this question, and Rabbi Bun, the son of Rabbi Chia, says, let us derive the resolution from the following Baraisa. Rabbi Eliezer said to them, I will prove to you that even SHECHIV MERA, somebody who's seriously ill and is on their deathbed, lying down, basically dying, cannot transfer property without a valid kinyan, contrary to the opinion of the rabbis. So this Baraisa here he's basically, Rabbi Eliezer is going to try to prove this position from an actual incident that happened, and the rabbis hold that the seriously ill person can effect a transfer of his property by the means of an oral declaration, but Rabbi Eliezer rejects that principle, and we know that in the Mishnah in Baba Batra, in chapter 9, Halacha 7, and he maintains that a seriously ill person must employ the same methods of kinyan as a healthy person, even if he's giving away all his belongings. So he's going to be trying to prove his point from an actual case. And here's how it goes. Here's how the story goes. The sugya reads, there was an incident involving a certain Meronite, that is somebody who's from the town of Meron, and who was in Jerusalem. And by the way, there's some dispute on that. The Rashi in Kiddushin 26b says that that's from the town of Madan in Joshua chapter 12, line 19. And the Mara Fulda writes that Maronite is from the country of Media. It's from the Media. It's from the country of Media. So in any way you want to read this, this is somebody who took up the journey to go to Eretz Yisrael, to Jerusalem, for one of the holidays of the foot, and that's why they're so far away from home. They are a stranger in Jerusalem. They are far away. They're Jewish. They're on a holiday of the foot, and clearly they got very sick. So the sugya reads like this: there was an incident involving a certain Maronite who was in Jerusalem, and he had a lot of movables that he wished to distribute, to bequeath to them, being the people in Jerusalem, as gifts. And he asked the sages how to transfer ownership of the property to the intended beneficiaries. So in this story, you can see that Rabbi Eliezer, he's assuming that this Maronite is a SHECHIV MERA, somebody who is on their deathbed, who wants to distribute his belongings because he's in fear that he's about to die. He feels that he's about to go. And perhaps in this story, the intended recipients were not present, so they could not perform the acts of acquisition. So the sugya continues, and it says, you cannot do so unless you have acquired land. That's what the sages replied back to this Maronite. But obviously, the Maronite there had no land to give the beneficiaries. So the sugya reads, what did he do? He went and he purchased a single boulder at the side of Jerusalem, and he declared, the northern half of the boulder I am giving to so-and-so together with 100 barrels of wine, and the southern half of the boulder I am giving to so-and-so together with 100 barrels of oil. And he had kinyanim performed to transfer the boulder to its designated recipients, and then he died. So the matter, says the sugya, came before the sages for adjudication, and the sages upheld his words. In other words, they ruled that the transaction of the wine and the oil was valid, and now at the time of the transfer, the benefactor was seriously ill, and thus, concludes Rabbi Eliezer, this incident proves that even a SHECHIV MERA can transfer property only by means of a valid kinyan. So, just a couple of notes here by the Mara Fulda. The rabbis told the Maronite to transfer the movables to his intended recipient through a kinyan agav, that is, by means of transferring a small plot of land to the recipients so they could acquire the movables incidentally. Just like in the story that we had where the heirs for the king acquired the movable property that was in the cities. So the sages recommended the same sort of tool to do that. The recipients could not personally perform the kinyan upon the land, since, as mentioned above, they were not present. Rather, a local person would perform a kinyan, such as a proprietary act, on their behalf. That's a note by the Ritva in Kiddushin 26b that somebody was acting as an agent to perform the acquisition of the land for them. So one might ask, says the Mara Fulda, why could the local person not perform a kinyan directly upon the movables on behalf of the recipients? Why was it necessary for him to perform a kinyan upon land, and only incidentally would the movables be transferred? Why does it have to be this way? So the answer is that practical considerations for were precluded for performing either of the two kinyanim, which are valid for movables. So, in one way, you have where a person makes the kinyan and he brings the object into his own private property, but that couldn't happen where he just gave it. He gave it to the person because the Maronite didn't trust any of the residents in Jerusalem to bring the objects into their property. So that they couldn't acquire it that way. And similarly, this other way called chalifin consists of a person who makes the kinyan handing over an object of some kind to the gift giver. And although the object is used to formalize the transaction, it is generally returned, and there is in fact no obligation to do so. In other words, normally, yeah, you can return that object, but you don't have to. So this Maronite would have kept it, and therefore nobody could be found who would jeopardize their object by handing it over to the Maronite, who is a stranger and is not trusted for this procedure by the residents of Jerusalem. So, since neither of these kinyanim could be performed because those people weren't there, and then these intermediary things of transferring it to an intermediary who would have to bring it into his house, well, the Maronite didn't trust that. He wanted to transfer it where he was doing it with land, and then only incidentally this would be acquired by the recipients. So I guess you could imagine that the barrels of wine and oil are in his house, and had he transferred the oil or the barrels of wine, 100 barrels of wine, it's a lot, to an intermediary, well, the intermediary can't acquire it without bringing it into his house. And what if the intermediary just disappears with the barrels of wine? How does the intended person get it? So that doesn't work. So what they had it where the intermediary acquired the land as a kinyan on his behalf, and the barrels basically stayed where it was. And so that when the person came to Jerusalem, the intended person could just go in the house and take the barrels. So that's basically the intermediary was only an agent to acquire it on his behalf without having to move any of the property. That's why it was recommended to do it this way. So that's quite a story that Rabbi Eliezer is bringing to try to be a proof to prove what happens if you have land over here and movable property over there in two separate places, to try to prove your point. In any event, this Baraisa proves that one can acquire movables along with land, even if they are not in the same place, because in this case, the movables and land were certainly not in the same place. But nevertheless, in this case, the sages ruled that the transactions were valid. And now the Gemara is going to try to deflect this proof, and it's going to try to deflect this. Rabbi Hananya said before Rabbi Manna, was this man not a SHECHIV MERA? Perhaps this is why he was able to effect a transfer even though the movables and the land were not in the same place. And the Sugya continues and says, for according to the rabbis, generally one cannot transfer ownership of land without a document or other act of acquisition. But here, in the case of the SHECHIV MERA, one can transfer it even with mere words. And therefore, there is no proof from this Baraisa, because it could similarly be, according to Rabbi Eliezer, that generally a person cannot transfer ownership of movables by means of a kinyan upon land, unless the land and the movables are in one place. But here, in the case of the SHECHIV MERA, reads the sugya, one can transfer it even if the land was in one place and the movables were in another place. So let me explain this by how the Rosh Cirillo says it. He's saying that although Rabbi Eliezer maintained that SHECHIV MERA, the person lying on his deathbed about to die, can transfer property only by the means of a kinyan, perhaps he agrees that the laws governing how the kinyan should be made are erased for such a person, for it is reasonable to assume that Rabbi Eliezer agrees with the rabbis that special leniencies apply to a SHECHIV MERA, and that he disagrees with them only with regard to the scope of these leniencies. Thus, perhaps the kinyan was valid in this case only because the benefactor was a SHECHIV MERA. In other words, what they're trying to say, this deflection on Rabbi Eliezer's point, is they're trying to say that, wait a second, this guy definitely was a SHECHIV MERA. He was on his deathbed will, and there's certain things now, when there's verbal designations, then that has a certain weight, and we have special allowances for that, so that maybe these special leniencies were done not because this is a normal way of transferring property. Again, what we're concerned about is when you have movables over here and physical property, land that's over there, that this is not a normal way to transfer this property, but it only applied in this case where the guy's on his deathbed and there's a special leniency. So perhaps Rabbi Eliezer is trying to prove his point only through a special leniency. So that's really a big thing. In other words, according to this reading, the local person is only performing this proprietary act on the boulder on behalf of these recipients somewhere else, and that it's only incidentally that they're getting the barrels through the kinyan agav, and they're saying that perhaps that it was only done because it's not a normal kinyan, but that's only done because he's it's a deathbed will, basically. He's basically giving on his deathbed. So that's quite a question. What are we going to do about this? So Rabbi Mana comes along and he replies, and basically he's going to reject this, and he's going to give a proof from the Brisa that basically is going to try to restore this idea that this is not a special allowance for a deathbed will, that in fact movables do not need to be located on the land, and that they can be separate. So this is not going to be a special leniency, according to the question of Rabbi Hananya, that Rabbi Mana is going to be implying and explaining that Rabbi Eliezer is going to be saying that this is in fact for all cases, whether it's an acquisition through deathbed or any other kind of acquisition, that the movables do not need to be located upon the land. And here's how the sugya goes. Rabbi Mana replied to Rabbi Hananya, is this incident not related by Rabbi Eliezer? And is there a difference, according to Rabbi Eliezer, between a SHECHIV MERA and a healthy person? Certainly not. A SHECHIV MERA, according to Rabbi Eliezer, is treated the same as a healthy person is treated according to the rabbis. Therefore, basically, they're saying that Rabbi Eliezer maintains that the acquisition was valid for a SHECHIV MERA, and that would have also been valid for anyone else. So why would this be applying here? If you think back and you remember in Peah chapter 1, there was a debate between Shammai and Hillel about if with the status of hefker. And Shammai says that if you say that, oh, I'm leaving this this grain as hefker, but it's only for poor people, that he says that anybody can come except for rich people to come and take it, and it's valid hefker. And Bet Hillel comes along and says, no, you can't make a designation for that. By definition, hefker is for anybody. So you can't make a limitation for that and say, oh, it's only for poor people, rich people can't take it. And he's saying that it's not valid hefker. So in the same way here, they're saying that a kinyan where you're having it for a healthy person has to be the same for a SHECHIV MERA, and in this case, where there's basically saying that there's no difference for this kind of acquisition, that where you have property over here and movables over there, and that basically they're saying that Rabbi Eliezer is saying that whether you are a healthy person, and basically they're saying that Rabbi Eliezer is saying that the sages say, the rabbis say, that you can't limit it, that you can make this acquisition whether you're healthy or not healthy, whether you're on your deathbed or you're healthy, where your property's over here and your movables over here, it's a valid kinyan, and that it's not a special case. And just want to make a point by the Pnei Moshe here. He says that according to this approach, the Gemara is concluding that Rabbi Eliezer did not relax the rules of kinyanim for SHECHIV MERA at all, and that therefore this brisa is proving that a kinyan agav is effective even when the movables are not located on the land. There's going to be a dispute in the Bavli and Kiddushin 26b, and it's going to deflect the proof from this brisa in a different way. But let's look at a different counter argument that's going to be used differently here than in the Bavli and Kiddushin 26b. So the Gemara is not going to be offering a counter argument. Instead, it's going to seek to prove from a second source that movables can be acquired along with land that are not in the same place. In other words, it's going to, instead of trying to refute it, it's going to go look for a different source. So perhaps Rabbi Eliezer's point is going to be sourced somewhere else, and maybe that's why the sages ruled this way in the case of this story, and perhaps we know this from somewhere else. So it was taught there in our Mishnah, and says the Sugya that Rabbi Akiva says, land of any size whatsoever is subject to the requirements of Peah and Bikurim, and it is fit to acquire movable property along with it by means of money, a document, or proprietary act. So the Sugya says, land of any size whatsoever, what is it good for? So that's a good question. So in other words, one cannot certainly stack movables on a tiny, minuscule postage stamp sized piece of property. Yet the Mishnah says that one can acquire movables along with it. And thus we see that movables do not have to be located upon the land in order to be transferred along with it. So this anonymous brisa is basically trying to say that Rabbi Akiva is saying that if you have a postage stamp piece of land that can only fit one stalk, well, if you're transferring property and there's there's movable property on top of it, that by very fact of how this is written, effectively they're saying that Rabbi Akiva is saying that you could have your 100 barrels, and you could, on this tiny piece of land that can fit one stalk, you could use that to do this kinyan agav, and you can transfer the barrels, and it's connected to the land, even if they're not there, because, hey, you can't fit 100 barrels onto this tiny piece of land anyway. And that's what they're trying to say. They're trying to say that Rabbi Akiva himself is proving it, that these are two separate things, that the movables need not be located on the land because, hey, this 100 barrels couldn't even fit on this piece of land that's this small. So the Gemara is going to deflect this proof, and Rabbi Matanya says, interpret the Mishnah as referring to a case where the land had enough room for a single stalk to grow, and a pearl was buried in the land. So the Bavli in Kiddushin 26b says the Mara Fulda is going to similarly interpret the Mishnah as referring to a case in which a pearl was affixed to a pin that was stuck in a minuscule plot of land. But the Yerushalmi, however, prefers to interpret the Mishnah as referring to the land the size of a stalk, wherein a pearl could be buried. But in any event, says the Mara Fulda, the Mishnah had to be speaking of land of this size regarding the requirements of Peah and Bikurim. So that's a very good insight. So he's basically saying, says Rabbi Matanya, that one cannot prove from here, from what Rabbi Akiva is saying, that movables can be acquired if they are not upon the land. So that's a big hiddush. So the Mishnah is going to state, regarding one who writes over his properties to others while he was seriously ill, if he retains land of any size whatsoever for himself, his gift to the others is not voided, even if he recovers from the illness. So the Mishnah and the Sugya is going to want to move on, but I guess the Yerushalmi is going to be going in the opinion of Rabbi Matanya, and that if you were looking at what is the halacha lemaisa, you would have to look this up, because it looks like Rabbi Matanya is deflecting the proof, and that's the final word here. So it seems that that's not the case, and that effectively what it's saying is it's effectively saying that the Yerushalmi is talking about this point about Rabbi Akiva because it's referring to Bikurim and to Peah, and that's why it's there, and that's not the case for movable property over here and real property over there. That's effectively where this is going. So what Rabbi Matanya is explaining is that the only reason that Rabbi Akiva is saying that is he's trying to make a point for Peah and Bikurim, and that it's not a statement, says Rabbi Matanya, for this case of property over here and property over there. And again, you would have to look up in the Rishonim for what is the halacha lemaisa in this case. So the Mishnah wants to move on. The Sugya wants to move on and read the Mishnah from the next part. It says, regarding one who writes over his properties while he is seriously ill, if he retains land of any size whatsoever for himself, his gift to others is not voided, even if he recovers from the illness. So the Gemara is going to clarify the type of seriously ill person, the SHECHIV MERA, to which this applies. In other words, who is this person? And in fact, the Sugya asks, who is the SHECHIV MERA referred to in our Mishnah? And it says, is it any seriously ill person whose illness did not spring up suddenly? So the commentary here by the Mara Fulda is basically that it is talking about somebody whose illness progressed gradually, so that if, however, a serious illness suddenly springs on a person, then even if he retains some property for himself, his gift is voided upon his recovery, because it is certain he was motivated by the fear of death. So this is talking about what happens when you have somebody who was sick, and they were sick for maybe months, and then they're giving away gifts, and they're trying to point out that the SHECHIV MERA is different, because this is a person who really believes fully that they're about to die. This is not somebody who knew they were sick and they've been sick with a long, slow illness. This is somebody who got sick suddenly and is on their deathbed and really believes they're going now. And that's what it's trying to talk about. So that this person who's afraid of it, being, with a sudden illness, not some illness that's been slowly going, but this sudden illness, that it's saying that this person has the gift voided on the recovery because he really had the fear of death. So the Gemara is going to try to limit the ruling of the Mishnah even further and try to box it in. And it's going to teach that when the SHECHIV MERA has a gradual onset of illness, the ruling of the Mishnah applies only within a certain time period. And the Gemara does this by citing a brisa which makes a distinction regarding the mitzvah of visiting the sick. So the sugya reads like this. It says, if one becomes sick in a normal way, in other words, his condition gradually worsens, the relatives visit him immediately. But those who are distant and not related visit him only after 3 days, when the illness has become more serious. However, if the illness springs upon him suddenly so that he fell seriously ill from the very start, both these who are related and those who are not related visit him immediately. And basically this Barais is teaching that when an ordinary illness comes for 3 days, it is considered to be in a different, more intense category of illness. And so too with the illness of the SHECHIV MERA that is going to be enduring for more than 3 days, it too is considered to be in a different, more dire, serious condition. So after 3 days, we assume that he is motivated by the fear of death, even if he leaves some property for himself. And therefore, in this case, he is eventually, and if he eventually recovers, the gift is void. So the Rosh in Baba Batra 9:18 is going to be saying, chapter 9, Halacha 18, is going to be saying that similarly, the laws of sickbed gift also apply in this case, since the gift was motivated by the fear of dying. Thus, a kinyan is not required for a SHECHIV MERA after 3 days of illness, even if he retains some property for himself. So the Rosh and the Rosh are going to be interpreting the words of the Gemara, where it's going to be saying, like, well, who is a SHECHIV MERA? And in the case of any seriously ill person whose illness did not spring upon him suddenly, there is a distinction which can be derived from the Brisa, which discusses visiting the sick, because just as the Brisa rules for that an ordinary sick person can be visited only after 3 days when he is considered to be in a more intense state of illness, so too one acquires the designation of SHECHIV MERA only after 3 days of illness. And similarly, in the case of one upon whom the illness springs, we can also derive from the later part of the Brisa that at all times he is considered a SHECHIV MERA and included in the Mishnah's rulings. So in the case of somebody where the illness springs immediately, according to the Rosh and the Rosh, they're saying that he's at all times considered the SHECHIV MERA. And in the case of an illness that came along gradually, that if things start really deteriorating and becoming intense after 3 days, and that it changes the behavior of how people are visiting them. In other words, it becomes known that the condition has seriously worsened, and the now you have strangers visiting them, non-family members visiting them. Sorry, then that's where he becomes a SHECHIV MERA. That's the point of the Rosh and the Rosh to help us to understand this. So the Gemara is going to resume this conversation, and is going to continue to try to understand the statement of the words of which the statement of the words that the SHECHIV MERA can use to affect the transfer of the property. And this is actually going to be a little bit of a thought puzzle and something to get you to think about this in a deeper way. I was thinking about this and I have an answer to it, and maybe we'll both come up with the same answer. So here's how it goes. It says, and these words have legal effect only where the SHECHIV MERA delineated the borders of the field he was bequeathing, and he also said, give this particular field to so-and-so. But if he merely is saying that one of his fields should be given to so-and-so without specifying which field, or without delineating the borders, the gift is not valid. That's what the sugya is saying. So, in other words, the rabbis are saying that the words of the SHECHIV MERA have legal effect only when he's indicating clearly the gift that he wants to give. And that in this case, he has to specify the field and delineate the borders, says the Mara Fulda. So let me explain the rationale for this. The rabbis enacted that oral directives of the SHECHIV MERA have legal effect only in order to save him from the undue anxiety. Thus, this from undue anxiety. In other words, he would be terrified that he's dying and can't transfer the property without some sort of technical, complicated written will and a proper kinyan, and that perhaps he's not in a physical state to do that, or it's too complicated, and so they're setting it up where to help ease the burden of the dying person, that he can effect a will that's oral and it's binding, but if he dies, it's a kinyan, and if he doesn't die, it's not a kinyan. It's not a valid statement. It's not a valid acquisition. So they're setting this up to try to relieve him of real anxiety. And this enactment applies only in situations where he shows an intense desire to transfer the property, where it is indeed likely that he will experience anxiety if his will is ignored. And this law is therefore limited to cases where he specified and delineated the gift, because it is assumed that this is what a SHECHIV MERA would do if he intensely desires to bequeath his property. So, in this case, they want to make sure that the borders are clearly delineated. There's going to be some technical reasons why they want to make sure that this person knows he's getting this, and this person knows that he's getting that, and so that it doesn't get mixed up. Because again, this is a special case and a special leniency. So they're trying to make it so that there's not going to be a confusion, that the person's wishes are really carried out in the way that he desired. In other words, that you're not mixing up the kinyan. You're not, this person didn't want, Mr. Jones to get X. He wanted him to get Y. And if it gets confused, he might get X, and someone else might get Y. So they're trying to make sure it's going to the right person for the right quantity of the right stuff with the right property. That's what they're trying to say. So the Gemara is inquiring, and it says, if a SHECHIV MERA delineated the borders of a field and said, give half of this particular field to so-and-so, and half of that field to so-and-so, without specifying which half should go to whom, what is the law? And the sugya continues. And it says, it is considered as if he delineated the gift, and it is thus valid. I'm sorry, is it considered? It was phrased as a question. So what is the law in this case where the person comes to give the gift, and he says, give half of this particular field to so-and-so, and half of the same field to so-and-so, but he doesn't say which half goes to whom. So the question is it considered as if he delineated the gift and it is valid, or perhaps he did not delineate the gift unless he says give its northern half to so-and-so and its southern half to so-and-so, and in the Yerushalmi, this inquiry remains unresolved. So in this case, in this case, it's saying that if you didn't lay out, you laid out who's getting what. You're getting this field, and you're getting half, and you're getting half. So you know which field it is, and you know who's getting half of it, right? But you didn't lay out which part of the field. And so the Yerushalmi leaves it unresolved. So I want to get into a conversation about this. So the Rambam is going to hold that if one specified the field, but he gave or he sold only a portion of it without specifying which portion, the gift is valid, and the recipient takes the most inexpensive portion of that field. But this ruling is going to be hard to understand on the basis of some of Rambam's other rulings, because this sugya leaves it as an unresolved question. And there's another explanation by the Rambam that has a competing answer. So what could be happening here? And I think that what's happening here is that the Rambam is right in both cases and in both places, but we're talking about different things. Okay, so what could it be that the person comes and he gives half a field to this person, half a field to that person, and the Yerushalmi would leave this unresolved? Why would it be? So if you imagine that, we have a field, and the north half has barley, and the south half has wheat. Well, wheat is always more valuable than barley. So which person gets the wheat and which person gets the barley? And so you don't know. So then would that have been a valid acquisition? Is that a valid gift? Because you don't know which person gets the more expensive part. It's not clearly said. So this is a case where it would be unresolved as to whether this would be a valid acquisition or not, because you don't know who gets what. And the other thing about this is that it's not enough for the SHECHIV MERA to merely specify which field he's giving. He has to identify the borders of the gift in order to be valid, and this requirement is certainly one which applies only to the rabbinical enactment that the words of the SHECHIV MERA have an effect. But ordinary gifts and sales of land can take effect when the land has been specified, even if the borders have not been identified. And the Rambam also makes that point in Hilchos Mechira in chapter 21. So this is a thing to investigate. In other words, under which case would it be that this would be unsolvable, and that the Yerushalmi doesn't give that answer? Because there are cases where you can arrange the field where certain things are left with value on them of different values, and then split it in half. And the question is, well, who would that who gets what, and would that have been a valid transfer? And so um, that that's a big question. So Yerushalmi ends this with a big question, and you know, the big question as to whether, the SHECHIV MERA, leftover land, and he left some for himself, and then he transferred the gifts, and then what happens? What happens in the future? Is that going to be a valid gift or not? So we're going to continue with the SHECHIV MERA tomorrow, and there's a lot here, and a lot of things that's going to help to sharpen our thinking to start to understand about movable property, and about permanent property, and about transfer and kinyanim, and what is a valid kinyan and what is not a valid kinyan. So let's do this again tomorrow. Thank you.